So I'll get right into introducing us and into the next slides in our presentation. So my name is Adam Karish, and I am the Chief Executive Officer at Karish.com. Karish has its headquarters in the Philadelphia area. We conduct hundreds of remote accessibility service sessions every week. We have been serving the community for over 40 years. We have clients in all 50 states in varying industries, and with our 24/7 in-house tech support, our team is basically made up of experts in accessibility services and remote solutions for ADA accommodations, and in particular for the deaf, the hard of hearing, and the visually impaired communities. And I'm joined today by Michael Torsha, Esquire, who's an experienced attorney, presenter, and a partner at a major law firm in the Philadelphia area as well. Michael, why don't you say hello?
Just say good morning to everyone. Thank you again, Adam, for having me today. I've been a labor lawyer for about 30 years here in the suburbs of Philadelphia, and my practice consists of providing advice to employers and businesses about a wide variety of employment law topics, including the ADA.
Great. I'll also take a moment to welcome our audience. So our primary audience today is educators and administrators from among our current clients all over the United States, but we also have some newcomers from outside our clientele, and we welcome you warmly. Thanks for coming. I'll just tell you briefly about what to expect today from our presentation. So with Mike's help, today's presentation will basically highlight legal liabilities, using legal case studies resulting from ADA law in education. And there will be a special focus on the deaf, the hard of hearing, and the visually impaired communities, utilizing distance learning solutions now. So we'll also be presenting how to kind of navigate avoiding these potential legal liabilities with kind of practical solutions. And that's where I come in with my team's experience. So this event might interest you, is also part of a series that we've titled ADA Compliance in Practice. And the series is focused on really the relevance of ADA law for the deaf, the hard of hearing, and the visually impaired. And so each session will showcase the legal and practical implications of individual ADA law titles. So today's meeting will be covering Title III in particular. So our next session will be focused on Title I and applications of ADA compliance in employment law. So at the end of our presentation, we'll have a little Q&A session. It'll be open to all the participants in the audience. If you have any questions during the presentation, please feel free to ask. Just use the chat box that you see on the side of the screen, and we'll do our best to get to any questions or comments that you have. We'll also be muting your mics to avoid distracting other participants. But your chat box function will remain active the entire time. So Mike, why don't I hand it over to you for the time being? Take it from there.
All right, thank you. So we're going to start off with an overview of the ADA. Some of you are familiar with the ADA generally, but we're going to be focusing on one particular title of the ADA. So just a brief refresher. The ADA is the Americans with Disabilities Act. It's a federal law passed in 1990 and covers a broad area of protecting people who are disabled and of disabled rights. There was a major amendment in 2008 called the ADA Amendment Act. Some people call it the ADA-AA. But that did many things, but in particular, it broadened the scope of what a disability is, of the definition of disability. So prior to 2008, there may have been people with certain health conditions that did not fall within the range of an ADA disability. After 2008, it's very difficult to eliminate certain health conditions from the definition of disability. So the ADA consists of 5 primary sections. Many of you are familiar with Title I, and that's employment. And those are the regulations that prevent discrimination if you are an employee. and requires employers to provide certain services and accommodations to employees. Very frequently discussed topic, of course, with employment. We're going to be focusing today, though, on Title III. And Title III is called public accommodations. It's actually called public accommodations and commercial facilities. So what does Title III do? Title III prohibits disability discrimination and requires access to places of public accommodation. Now, public accommodation doesn't mean only entities or businesses that are public. It's not just, you know, public government, county government, or public colleges and universities. It means any private entity that provides services to the public. So the word public here means it's provided to the public. So for example, you'll see in the second bullet point here, really almost any business. So restaurants, movie theaters, schools, daycare facilities, and the list goes on. It also regulates businesses that are newly constructed. So again, many of you are familiar with Title III, even though you might not have known it was Title III. If you walk into a building and you see that there's a restroom that's ADA accessible, or has large stalls, or has certain faucets that are designed for the disabled, that's a Title III public accommodation. Now, importantly for this presentation, Title III also includes colleges and universities, schools, and most importantly, all communications coming from any of them, online, courses, internet content, and school announcements. And we'll hear more about that, especially when we get into the case studies. We have two example case studies to bring to you a little bit later. Let's jump right to the bad part, the penalties. Why fool around, right? Let's get to the bad. The penalties for non-compliance. So if you are an entity that provides public accommodations and you don't do what you're supposed to do under ADA Title III, here's what can happen. There can be investigations and compliance reviews by the Attorney General. There can be private lawsuits, and that means that the disabled person or persons can bring a claim against you for not providing the services. There can be lawsuits by the Attorney General. And the relief that can be granted to disabled persons or groups of disabled persons is really very broad. You'll see here that there are, 7 or so bullet points, but really when you add them up, it's almost any relief that a judge or a jury decides is necessary to remedy the situation. So the first bullet point there, temporary, preliminary, or permanent injunctive relief. Injunctive relief means that the court is telling you that you have to stop doing something, or the court's telling you you have to do something. It's an injunction. Providing an auxiliary aid or service, and that phrase is bolded because we're going to be talking a lot about auxiliary aids and services. Making facilities readily accessible, monetary damages when requested by the Attorney General. Interestingly, if a private individual brings a claim, they can't get money. They can get a fix, they can get a remedy, they can make you provide certain services, but ordinarily they just can't get money damages for that claim. The Attorney General has to ask for that. There could be civil penalties up to $55,000 for the first violation, $110,000 for any other violation. And then punitive damages. Punitive damages is punishment. Normally, punitive damages are awarded if you knew that you were supposed to do something and didn't do it, or it was particularly egregious. Courts will allow and award punitive damages. And then attorney's fees. And that means the other person's attorney's fees. You may be paying your own attorney, but then you're paying the other attorney as well. What's important to know, again, for this session, is that the courts take into consideration good faith efforts to comply. They'll consider whether the entity, the business, could have reasonably anticipated the need for an appropriate auxiliary aid. So what does all that mean? Well, that means that if you knew the disabled individual needed an accommodation, but you didn't provide it, there will be larger civil penalties. One of our two case studies that we'll talk about later on, the second one is a case called Argeni. And you'll see that the plaintiff in that case, the disabled person in that case, brought a claim and asked for, I think it was about $135,000 in monetary damages. And the judge said in that case that the court did not find bad faith. They found that the college in that particular instance acted in good faith and did not award money damages. So good faith efforts, what we're doing here today, learning about the accommodations and then implementing the accommodations go a long way to, number one, stopping lawsuits, and number two, making the penalties much less severe. So let's talk about that auxiliary aids and services phrase. What does that mean in real life, just not taken out of the regulation? Well, the basic rule under the ADA is no individual with a disability can be excluded, denied services, segregated, or otherwise treated differently than a non-disabled individual because of the absence of auxiliary aids and services. So that makes sense. You need to provide accommodations essentially to a disabled person. Now, there are exceptions to that. You don't have to provide every accommodation in every circumstance. And sometimes, and I've been representing businesses for many, many years, sometimes businesses will grab onto this exception and they will say, oh, look at the exception. We don't have to provide the accommodation if it would fundamentally alter our business or if it's an undue burden. And it's very common for businesses to say, oh, well, this is an undue burden. This would be very annoying to have to do, or it's going to create a morale problem with our other employees, or it's going to cost us $1,000. That's not what the regulations mean. When they say undue burden, they don't mean it's annoying, they don't mean that it's inconvenient, and they don't mean that it's going to cost the business some money. They mean that it would have to almost fundamentally change the profits of the company or of the school or of the business. I mean, it has to be a severe change in order to rise to the level of undue burden. For example, if you were in a building that could not be altered for the ADA would not require you to purchase a new building or to move your offices to a new building. That would be considered an undue burden. But I will say, it's not wise to test the fundamentally alter standard. In fact, I'll give you an example of what the EEOC says about fundamentally alter. They give an example that if a bookstore does not normally special order books, they would not be required to special order books for someone who's disabled. Now, I have to tell you, if I didn't see that in the EEOC regulations, I would never have guessed, and I would never have advised a client this way, that the bookstore wouldn't have to special order. That doesn't cost very much money, doesn't seem like very difficult to do. There's another example that the EEOC gives, that a restaurant would not be required to prepare a special dish for someone who's disabled. Okay, maybe, I guess, depending on what it is. But my point is, these cases are all over the place, and you have courts that are deciding, well, this would fundamentally alter the business or this would not fundamentally alter. That's very risky to not provide accommodations based on that. So the next basic rule is public accommodations, public accommodations shall furnish appropriate auxiliary aids where necessary to ensure effective communications. So on the topic of communications, it makes sense that you'd have to provide whatever aids necessary to effectively communicate. But the type of auxiliary aid or service will vary according to the method of communication used by the individual and some of these other factors, the nature, length, complexity of the communication. You can see how difficult it is to try to have a rule or regulation that covers every situation. So the regulations don't cover every situation. They say you need to make sure that people have equal access, and it depends on what's happening with this particular person. I am not going to read you all these words here. There's a lot of words on this, but I put it here just to impress you about how complex this can be. Number one, this is the definition of auxiliary aids and services. Number one really talks about people who are hearing impaired. Number two really addresses people who are blind or sight impaired. And I highlighted a couple of terms here that for the hearing impaired under number one, it could be, you know, all of these things or a combination of these things, including open and closed captioning, including real-time captioning. And by the way, this list is not necessarily exclusive. You know, it says the term auxiliary aids and services includes. There could be other things here that are not listed, and it's certainly as the technology evolves. And then under number two, for sight impaired people, they mentioned braille material displays. And then this is what lawyers love too. Look down the bottom, number four. Other similar services and actions. You know, that's Congress saying, yeah, and everything else, and anything else that you might have to do. All right, so nothing, I think the point's made that nothing in the actual text of the ADA specifically requires the use of closed captioning, visible text, subtitles, etc., because the regulation, as we just saw, allows for flexibility and what accommodation you need to implement. But many of the alternatives have either been replaced or disfavored. And again, we really need to keep up with industry standards, as we'll see. All right, I'll let Adam take it from here as a good segue to, practically speaking, what are we talking about?
Great, thanks a lot, Mike. Yeah, just like Mike was saying, or he was touching on, Title III requirements are equally as relevant to on-site educational settings as they are to online learning. You might have captured that from what he was saying. And as we'll discuss in the case studies coming up, the requirements include pre-recorded coursework and live classes as well. And that's the reason we titled this whole session in and around distance learning, because there's a lot of application to what's currently going on in the world and the way that you're teaching your students or participating in classes. So the cases that we're going to talk about show that equal access is required for all school content showcased online. That goes for the audio and the video content on school domains and on third-party web platforms. We'll also talk a little bit about real-time card captioning, which is perhaps the most ubiquitous and inclusive accommodation for the deaf and hard of hearing communities. And that cart captioning or some equal alternative is required for all new video or audio content on websites provided by your school upon a specific request for or by an individual who's unable to access that specific content. So we'll get into how that affects you in the classroom in a moment. And in the cases of MIT and Harvard that we'll be covering a little bit later, in those settlements, which we'll be delving into, the school was just given 5 business days basically to provide the content that we'll be talking about after receiving such a request. Just five business days. So this will go for any new content created or produced by a school, posted on your official channels, YouTube, Vimeo, SoundCloud, whatever it is. So this is relevant for the schools, for their museums, for their libraries, and importantly for events. So this will delve into your legacy content and all of your live events as well. So in the case settlements that we'll be looking at, it's specified that the schools must provide what they call industry standard live captioning. We'll define that a little bit later, but that has to be provided for all of their events for which there was video or audio that was live streamed over the internet. So this is an example for some of you, might be commencements or ceremonies, presidential installments, any other type of high interest event where you're going to have other participants. So all of this, along with what Mike was saying earlier, might have raised some questions, but don't worry, we'll be digging into the details based on the case studies and the requirements in the next section of the webinar. So were you able to move? Yeah, there you go. So I'm going to talk to you a little bit about permissible accommodations. So Mike spoke about how the ADA law stipulates kind of a specific list of auxiliary aids and services, otherwise referred to as accommodations, pretty much the same thing. And although the federal regulation proposes a very long list of specific accommodations, and that list includes, in some cases, kind of arcane or outdated recommendations, such as telephone handset amplifiers, or simply exchanging written notes. Several are mainstream, popular, and commonly used at universities, colleges, high schools throughout the United States. So what we decided to do was focus here on 4 of kind of the most universal solutions, or solutions that might be applicable for the people participating in this call as attendees. And this is based on our experience basically with schools in all 50 states at different levels, K through 12 and universities. So all of these accommodations we'll be talking about can be provided remotely or on site, with one exception, prior to, during, and most probably after this COVID-19 crisis. So all these examples are equally relevant solutions for your on-site teaching, as well as your distance learning scenarios that you are probably currently experiencing. So I'll be talking about 4 major groups of these accommodations. The first is real-time captioning. The second is transcription and note-taking, and that's for mostly pre-recorded audio files. The third will be qualified interpreters, on-site and remote, like you're observing today. And the fourth will be dedicated services for the visually impaired, not for the deaf and hard of hearing, but for the visually impaired. So for the, in terms of the first group, real-time captioning. So sometimes real-time captioning is referred to as CART captioning. A lot of you on this call are probably familiar with the term. CART is an acronym that stands for Communication Access Real-Time Translation. And it is basically the process of turning the spoken word into captioned text. So CART is provided in real time, so it's live, for an individual or a group of any size and in any setting. So the speaker's audio is transmitted from the microphone to our certified captioner, and then it's displayed as text on a larger screen, on a monitor, on a laptop computer with 98% accuracy or better, and that all happens within 2 to 4 seconds. So what's also relevant is that within this kind of real-time captioning category, we also have internet captioning and live streaming for all of your live streamed events that are on the internet, as well as videos that you might upload or stream on sites like YouTube or Vimeo. We also include meaning for meaning captioning in this category. This is a real-time conversion, so live conversion of speech into summarized text for individual viewers. So this service is most often provided in education, but also in meetings and appointments, board meetings, municipal gatherings, etc. So you might have also heard of Typewell or cPrint, but these refer basically to software, which meaning for meaning is provided in. So in terms of the end user's experience, cPrint, Typewell are identical to one another. Also in this basket, finally, is broadcast captioning. So some might say that broadcast captioners are kind of a category of their own. They often have the most training. They are the most experienced in many cases, and they often take the toughest jobs while still maintaining this 98% accuracy under very high pressure in many cases. So we'll often use broadcast captioners for programs on television, as well as large-scale, live public events, or if a client basically requests that. So the next slide is a second category that we have kind of grouped together for pre-recorded audio files. And here you basically have transcription, note-taking, and offline captioning. So transcription, very simply, is the creation of a 100% accurate transcript, a verbatim transcript from a pre-recorded audio or video file. Note-taking, as you know, is the process of taking verbatim or summarized notes from lectures or meetings and presenting them in some type of readable format. And when it comes to note-taking, there are myriad formats, levels of accuracy, turnaround times available, et cetera, depending on individual needs of the student and the school. And finally, offline captioning, which is basically closed captioning for pre-recorded materials, and that's used for broadcast and internet videos. The captioning can basically be turned off, hence the name. Offline captioning on or open captioning is similar to closed captioning. The difference is that captions cannot be turned off. So these are often referred to as subtitles. So in this third basket, which is the next slide, we have grouped qualified interpreters, and that's on-site or remote. In this group, we're talking about just two of them, American Sign Language, or ASL, which you're viewing today, can be provided on-site or remotely in the classroom. There's really no difference, but you have to have the right technical setup to allow for it, and a solid, strong internet connection on both ends. This is good for business meetings or events, but definitely for the classroom. So you want, you basically only want to permit trained and certified ASL interpreters to cover classes and meetings to ensure the best real-time service available. Another service in this area with qualified interpreters is tactile ASL, or tactile signing. Tactile signing refers to signing using touch. It's a common means of communicating used by people with deaf blindness. It's also based on sign language or some other system of manual communication. So interestingly enough, directly before the COVID-19, before COVID-19 hit, our team participated in a placement process to help a deafblind middle school student in Pennsylvania. And she required basically full-time tactile ASL interpreting in school with her every day. And we were able to send out several strong candidates almost instantaneously, which was very rewarding. But we found that interesting. It's not a very common need or common request, but it is important for those who need it. So keep in mind that the accommodation that you select, it must be, and you have to be attentive to your students' very specific needs. Some people are late deafened, so they're not born deaf, and they don't know ASL. So captioning is perhaps a better option for them. Those fluent in ASL, on the other hand, they take great pride in their unique language and their unique culture, and they may even be offended by captions as an alternative to ASL interpreting. So in some cases, as in the case of today's webinar, both is often the best option, or the safest option perhaps. And finally, there's a fourth kind of basket that we're going to talk about, and this is dedicated services for the visually impaired. And I will only present two of those. One is what we call real-time Braille cart, and this is interesting, might be interesting for some of you. So in partnership with a longstanding client of ours in the Philadelphia area, Temple University, which I'm sure you all know, our and their teams came up jointly with kind of an innovative solution for students who had who were both deaf and visually impaired. And what we call Braille Cart is provided by a certified expert cart captioner who then connects to the individual student's Braille reader. And this, for all intents and purposes, allows the end user to interact in real time with basically any environment. So in this context, though, it is worth noting that real-time Braille Cart is not a fully remote service. The second one that we've thrown into this basket is audio description, also for the visually impaired. So this is an interesting service or tool that allows the visually impaired individuals it allows them to, or it's basically a narration of the actions and the events that are taking place in a video or at a live event. So until COVID-19, until all of these restrictions, struck, we were providing this service for training seminars, for plays and theater productions, etc. But currently, this is primarily ordered for pre-recorded materials rather than live events. So I think at this point, we're going to be moving right into our case studies, which I think a lot of you will find very interesting. So what we're going to do is Mike is going to walk through the actual case and the settlements and what they're about, and then I'll give a little commentary on the end from the practical side.
All right. Thank you. So we have two case studies to talk about. Before I just jump into this, it may go without saying that there are many, many cases. I mean, there are hundreds of cases, and probably thousands of cases that are actually filed. The vast majority of cases generally do not reach a trial. They resolve, they settle, so you never hear about them. And there's not a very good way of really tracking what those settlements are and what those resolutions are. These two cases, the first case study, are actually two combined cases. The National Association of the Deaf, the NAD, filed cases along with some individuals against Harvard University and against MIT, Massachusetts Institute of Technology. And they were class action lawsuits, both brought in Massachusetts federal court. And the NAD alleged, the plaintiffs alleged, that the college's failure to provide equal access for the deaf and hearing impaired individuals to much of the audio and audiovisual content the colleges made available was a violation of the ADA. So the colleges were providing audio and audiovisual content to the public, free to the public. And they were also providing online courses, of course, to the students. And they were doing other things like televising or having through video graduation ceremonies or award ceremonies, those sorts of things. The plaintiffs argued that the colleges violated the ADA because of the lack of quality that they used, and the fact that they didn't do it at some point, and also because of the lack of comprehensive video captioning in the MOOC, the massive open online courses made available to the public. So the defendants, the colleges, defended themselves, of course, and they argued that their websites and the other online content were not, quote unquote, places of public accommodation. And therefore the online content was not an aid or a benefit or a service requiring equal access. So it's interesting, the colleges were not saying, oh, we're doing a fine job at it. What they said is, we don't need to do any job because this is not under the ADA. This is not a place of public accommodation so that we need to even worry about this. And as it turns out, they were mostly wrong, the colleges. In this case, they defined caption or captioning, and these were private settlements, which I'll get into in a minute. And again, I won't read you all these words, But what's important here is when they define caption and captioning to include these various processes, they specifically stated that they need to be offered, and you'll see the bolded language here, in a manner consistent with industry standards. Now, in any industry, that's a moving target. You know, what is an industry standard? What was an industry standard 10 years ago may not be today, or 5 years ago. In some cases, last year may not be an industry standard. So it's very important that people in the industry keep up with what is considered to be an industry standard. And that goes back to the good faith point from before. You know, you need to be acting in good faith with these. So what happened? What happened with these cases? Well, both cases settled. And as I said, most cases do settle before they go to a trial, but these went on for a very long time. The Harvard case settled first. And in the Harvard case, which settled in November of 2019, both sides agreed that they wanted to provide auxiliary aids and services to the disabled, and they wanted to make sure that everyone had equal access. So that settlement between the NAD and Harvard covered student online courses, interactive courses. It covered video and audio. It covered things that they had on the YouTube channel. It definitely covered that massive open online course content, that MOOC, you know, that acronym MOOC. It covered legacy content. It covered videos that had already been out there. They were required to go back and provide captioning to that. It covered, as I said a minute ago, the ceremonies and the commencement and those sort of live streamed events that the colleges were putting forth. And then it kind of covered a catch-all, which was if anyone requests that a video or a presentation or an online stream be captioned, then the college had to, in good faith, either provide it or at least consider it or explain why it didn't work. Oh, and by the way, the court, the settlement also gave the plaintiffs over $1.5 million in attorney's fees. You know, there's always the money. MIT settlement was a little different. Now, these cases, even though they were separately brought, they're under separate case numbers. When they had conferences with the court and the judges, they spoke about them together, and the court really looked at them together. So they were related. But MIT didn't settle for a little while later. MIT, interesting, did not cover student courses because they said that student courses are separate. They were separately being addressed. They weren't ignoring them. They still had to provide captioning and other services for the courses, but that wasn't in the settlement agreement. But same thing, basically. MIT agreed to provide captioning for certain conduct, including the legacy by request, the online streaming, the ceremonies, and all of that, and about $1 million in attorney's fees. What's important to note is that these were not rulings by a court. These were settlements among the parties. So the terms of the settlement, whatever they decided on, how many days they had to provide something, the money that was paid, exactly what they had to do and when they did it, is not binding on any other parties. So a settlement is a private settlement. You know, in any case, it could be whatever they decide. However, because these were, you know, so high profile cases in this area, they're very instructive about how some of these matters could or would get resolved. Adam, you want to talk about the resolutions here from a practical perspective? I think you're muted. Are you muted?
Can you hear me now?
Now I can. Now we can hear you.
Okay,
Yeah,
excellent.
Yeah,
Thanks.
Go ahead.
Yeah, so So as of February 2020, the NAD versus Harvard and the NAD versus MIT, both lawsuits have been settled. And as Mike was talking about, they came to consent decrees, settlement agreements between the parties. And according to the NAD, both settlements represented, and I'll actually read a quote here, the most comprehensive set of online accessibility requirements in higher education, and provides a new model for ensuring worldwide online and digital accessibility in academia and business for people who are deaf and hard of hearing. So this is a huge milestone, the settlement agreements, and that's why we chose them for today's webinar as well as an example. Now, although the NAD versus Harvard and versus MIT settlements can't be treated as specific precedent for other cases, it does give us a useful behind the curtain look at a sample situation similar to ones that you and your schools might find yourselves in. So in this case, as Mike was mentioning, it took 4 years of litigation to reach a settlement. The good side of all that litigation is that it really strengthened Harvard's and MIT's and potentially yours as viewers of this situation, new digital accessibility policies. So they established, Harvard in particular, established captioning guidelines so that Harvard University could continue to improve accessibility on its online resources, and for all those who are deaf and hard of hearing, however they're consuming their content. So it's also worth noting that Harvard, previous to all of this, had been captioning already much of its online content prior to the litigation proceedings. So very importantly, the settlement simply guaranteed that the university had to provide high quality captioning services for their online content from that point on. So what I'd like to do is take a kind of practical look at two of these stipulations in the mutual agreements that we've just been talking about. So the first one I'd like to focus on in particular is what was called industry standard captioning. And as Mike was saying, what does that really mean? What is industry standard captioning? Now, we've got two situations. Basically, any professional agency needs to put years of consistent work into maintaining industry standards, whatever those industry standards may be at the given time. But that definitely requires demanding and then checking that their captioners have the proper certifications, applying a proper vetting procedure, matching a captioner's experience to a particular deaf student's specific needs. So this case study with Harvard and MIT that we were talking about refers specifically to offline materials, so pre-recorded content. For pre-recorded materials, the expectation is nothing less than 100% accuracy, as well as professionally timed in captions. That assumes that you need an SRT file record of the event for publishing purposes if you plan to post it afterwards, like these schools did. It's worth noting that this same standard applies in American Sign Language interpreting as well. Now, that was for offline material. If we look at real-time scenarios, the industry standard captioning refers not only to the accuracy, but also to the certifications. So accuracy during a live event has to be at least 98% for all the real-time captions. That's basically what's expected. In terms of certifications, in order to provide this industry standard service that we're talking about, captioners are required to take years of training, specialized software and hardware. They typically have national and often additional state certifications. At our firm, for example, they also have to go through a rigorous internal vetting process, so that helps for the end user as well. It's for this exact reason that artificial intelligence solutions that you might hear about, which are all asynchronous at this point, simply do not meet industry standards, especially for real-time scenarios. So I think this is a very good point to hand it back to you, Mike, and you can run us through the second case study.
All right, case study number 2. This is very different than case study number 1. So case study number 1 was a class action, many plaintiffs or potential plaintiffs. It could have been hundreds of thousands of plaintiffs really in the first class action, theoretically. Those were resolved by settlements, by consent decrees, essentially. This is very different. This was brought by a single individual, by one student, a medical student, against Creighton University, excuse me, and was not settled. It went to a trial, which is unusual, and again, statistically unusual. So this was a medical student who went through 4 years of medical school at Creighton University. He was hearing impaired, and he brought this action under Title III. The plaintiff did not know ASL. He did not know American Sign Language, but relied on lip reading and cued speech, hand signals to represent sounds. He also relied on CART, as Adam was talking about, and he paid for interpreters himself for his first couple of years as a student, and he himself paid for the CART services. The defendant, Creighton University, denied the use of interpreters. Now, that sounds a little harsh when you hear it like that. Oh, they denied the use, they wouldn't give him an interpreter. But it wasn't because they were trying to be harsh. It wasn't because they were trying to discriminate. In fact, in one of the legal opinions, the court pointed out that Creighton University was one of the only universities that accepted Mr. Argeni, even despite his disabilities. So the court gave Creighton credit for admitting him in the first place. But they denied the use of interpreters because they said they believed that it would be better if a future doctor, communicated with the patients without the use of a third party, and were encouraging him to do something else other than the use of interpreter. And he insisted that he needed an interpreter for certain parts of his education, for classes and those sorts of things. So the case went to trial. And because an individual cannot get money damages, himself or herself, there were 2 parts of this trial. There was a jury trial, and then there was a motion where the judge had to make a decision. So it goes to a jury, and the jury decided in his favor, in Mr. Argeni's favor, that there was discrimination on the basis of Creighton because they did not provide these accommodations. And they also found that it would not have been an undue burden for Creighton to provide interpreters and CART services and those sorts of things. Without getting into too much of the detail, Creighton argued that it would have been a burden financially and would have changed the nature of some of their classes and other presentations. So the jury ruled in his favor, and now the plaintiff filed a motion with the judge asking for specific relief. And the plaintiff wanted a variety of things. He wanted the services. He also wanted, as I mentioned, about $134,000, $135,000 to be reimbursed for what he had spent in his first 2 years as a medical student. Well, the judge ruled that the school did need to provide him with these auxiliary services, including CART in didactic settings and teaching settings, and science-supported oral interpreters in small group and clinical settings. So essentially, he got what he was looking for. The court also awarded $449,000 in attorney's fees, essentially reimbursing the plaintiff for the fees that he spent or the time that the attorney spent, and $30,000 in costs. But interestingly, and I mentioned this at the top of the seminar, no other monetary damages. So the court looked at this and said, Creighton did not act in bad faith. It turns out that they were wrong under the law, but they did not act in bad faith. They weren't doing it for a bad reason. Like Adam said with Harvard and MIT, Creighton was providing certain services to disabled individuals even before this lawsuit. So the judge did not allow any money damages as a result of that case, even though he did allow the auxiliary services to be provided. So that was our Jenny. And Adam, I'll let you talk about the real life implications.
Yeah, thanks. I'm going to keep this very short because we're already coming up to an hour. And I do want to have time for a couple more slides, brief ones, and for some really great questions that are coming up from our attendees. I definitely want to get to those. But I personally find this case study really just fascinating and very telling. On its face, it would seem that the student simply required captioning, right? But as we delve deeper, we see that the student's needs were more subtle, that the school's requirements were more demanding. And this case study shows once again that accessibility accommodations, especially in an educational setting, they don't offer, or you can't get one size fits all solutions. Oftentimes schools, in fact, don't know exactly what they need, and they're looking for experience-based guidance. That kind of brings me to my next and final slide before we get to the questions from you. I'll try to keep this very short. And we were joking with Mike that this slide is not a sales pitch, even though it might seem that way. But we did want to take the opportunity to tell you a little bit about what we're doing in this space in case it comes in handy. So earlier I was outlining the dedicated services for the visually impaired. I touched on real-time Braille cart. That's really a superb example of the Carish team's flexibility and our mission to fit our clients' unique accessibility needs, and to adjust on the fly sometimes to whatever's thrown at us in terms of your needs or clients' needs. So throughout this presentation, I've outlined several accommodations that are relevant for the deaf and the hard of hearing and the visually impaired communities that most of you at least, you work with every day. So we provide all of these services to schools just like yours throughout the country every single day, K through 12, universities, and in a business setting. And we have been doing this for decades. So please remember, when it comes to ADA compliance accommodations, don't wing it. Reach out to us for advice. Reach out to Mike as well for advice on the legal side if need be. There's no need to be fearful or apprehensive about moving your student-teacher interactions remote if you're prepared. So it can actually be an improvement if you have the right infrastructure and the right support. Now, I was going to briefly walk through some practical components like the setup and testing, tech support considerations you might want to think about when you're setting up your accessibility services, security issues, but we're a little bit short on time and we've already come up to an hour. And so I'm going to skip that. I'd be happy to tell any of you about those considerations, just walk you through them to help you get up to speed. Just contact me after this, and I'd be happy to walk you through them or send them to you. But I do want to leave enough time for us to get to some of these questions. So I'm not sure, Mike, if you had a chance to actually read through them, but I will try to get to them right here, and I'll read them out loud, and then we'll go from there. So Kelsey writes to us, I'm curious how to handle situations like this when special education admins give pushback to expensive services such as real-time captioning, CART, CPrint, or ASL interpreters, etc.
That's easy. We can send them a copy of the Argeni case. We can, yeah.
Right.
I mean, look, this is real life, right? This is exactly the real life situation where there are budgets and there are time considerations, and you might be spending a lot of money for a relatively small group of people. I think that I mean, look, I'm biased, right? Because I'm an attorney and I give advice in this area. But I would say if someone is pushing back on giving an accommodation that is really necessary to provide equal access, contact an attorney, contact your local attorney or an education attorney or someone who represents, the school, or encourage, administration to do that. And let's say, like, let's just have a conversation about this to understand the risks, because again, it's going to be, you're not going to win. There is no winning in these cases. What's going to happen is you're going to end up resolving this in some way and providing the service probably after, paying the attorneys a lot of money, which is totally avoidable.
I would add one item here, and again, I'm not a professional consultant, so this is not by any means legal advice from my end, but it is based on my experience and my team's experience, that there is a different way to deal with these requirements for the K-12 space, K through 12 space, and then after a student or pupil becomes 18. So if we're talking about grammar school and high school, there's the 504 plan, there's the IEP, and that whole procedure is very precise, and your rights should be very clear, and there shouldn't be as much perhaps pushback in that case. When we're talking about an adult, then there's the Argeni case. There's all this dialogue, the goodwill that Michael was talking about, and maybe it becomes a little bit more complicated and potentially a legal conflict. I'd be happy to talk to you more about that. And we're in touch with advocates that help students, they help counselors, they help, parents. So I'd be happy to help you, point you in a direction that might be helpful to you. So please reach out to me afterwards, or to Mike and myself afterwards. I'm scrolling down to look at additional questions here. So Adina wrote, the challenge for us is that it is always the service provider that tries to determine what delivery method they want to provide. And it's not necessarily effective, but most often the cheapest one.
That's you.
Yeah, that's me. Yeah, I mean, that doesn't sound very professional from the the little blurb that I got from you, Adina. Yeah, I mean, there might be certain limitations that a certain agency or intermediary has, and therefore they're forcing a delivery method onto you. But yeah, we can't afford to be doing that. So I'm not really familiar with that type of protocol. So typically the way we start is we ask the client what they need. We try to get a feeling for the specific requirements of the child or of the young person, of the student or the employee, whoever it is that needs the service, but also what type of infrastructure the school has. So oftentimes there are just infrastructure issues like a very poor internet connection. And in that case, certain solutions are very difficult. But it's really a case by case. But in no case should the agency or the intermediary be forcing upon you, the client, some type of solution and not be listening to your needs. So I hope that answers your question. But you are the client, you are the one in need, and you're the one that the ADA law is here to protect. So keep that in mind. It's not the agency, and there are many agencies and many service providers. So, shop around. The next question, oh, I guess this is also Adina, sorry. Again, it is a challenge for deaf and hard of hearing individuals to convince employers, schools, that we should be able to determine which interpreter is qualified for us. Yes, indeed. We tend not to be able to have a word in the matter. The burden of proof of ineffective communication is on us, and it is stressful. Yes, we experience that every day. It's an issue for employers and an issue for schools. It's really a case by case. But if you want to contact me after this webinar, I'd be happy to talk about your situation. Maybe there's a way that we can help. I hope that this webinar is actually, it might give you the tools to speak the arguments, to speak to an employer or speak to a school admin about the real litigation risk that they are putting themselves in by not giving you the proper service.
Adam, there's two that might be good for you before we wrap up. If you scroll down a little bit from Melissa,
Yeah.
1059, that looks like one for you. Can we get a demo of services?
Yes, yes. All you have to do that's free of charge if you want a demo for services, depending on what you need. Almost all of them can be provided remotely. We have a full tech team that can run those demos for you. So just contact us. We can make it very short, 5 or 10 minutes. If you want something more extensive or for an entire team, like we sometimes do for schools, we'll get a whole team of special education teachers as well as their students in some cases, and they'll all get on the line and we'll walk them through, how the service works and what they'll need in order to have the service delivered properly, or what their limitations are. I also see a question here from Melissa. Should public announcements also be captioned? Can you conduct an accessibility audit of our school? Great questions. Maybe I'd put the first one to you, Michael. Should a public announcement also be captioned?
Yes, I would. I mean, I think that's covered. Again, the settlements that we've seen from examples like Harvard and MIT, they're not necessarily, legally binding, but they would cover something like that. They would cover, public announcements. So things coming out of the schools, I would. If someone is sight impaired or hearing impaired, then you would need the captioning for them to understand it.
Mm-hmm. I also have an interesting question here from Shelby, and I'm not sure. This is really a question to you. So if I'm using electronic resources that screen readers cannot read correctly because my discipline is full of topics and terminology that screen readers cannot recognize, that's kind of the AI that I was talking about previously. I'm at least covered by the good faith for having tried. I'm not sure.
Yeah. There's no answer to that. there's not an answer to that, because you're talking about, again, it would probably never get to this point, but we're talking about a judge or a jury deciding how they feel about that. Well, do they think it's good faith or not? It's certainly better than not having tried at all. But if you know that there's a more effective method and you're not providing it, and that has an effect on disabled individuals, it might be a little difficult to argue, hey, well, I tried and I didn't do anything else. So.
Right. Yeah, it would be best to just provide a proper industry standard service.
Right.
And the school should cover that cost, or the employer. I'm trying to read.
Is there one down the bottom from Anne?
From Anne.
What accommodation would you suggest?
Yeah, I'm trying to get it here. What accommodation would you suggest for a student who is deaf in an online Zoom college course? So, right, we do hundreds of these every week. We have, whole schedules of them, morning through to the evening, every single day in all the time zones. So a student who's deaf in an online Zoom college course, if it's not pre-recorded, if it's live, I assume that's what you're asking about, Anne. For live courses, it would be probably CART captioning. It could also be note-taking. That's another option, or CPrint, which is a lot like note-taking. And of course, ASL might also be an option. It really depends on what the student wants and needs. So you should start by asking the student whether they would prefer ASL or captions. Now, there's an added benefit that I'll add here, is if it winds up being captions or note-taking, then we could help you provide notes to all of the people in the classroom and to the professor or the instructor heading the class. So that's an interesting option that might be an additional benefit for the other students in the class and for you as a school administrator. So I'd be happy to talk to you about that later. Does a college, this is from Wilma, does a college have to provide all accommodations that the student requests, or is it based on students' medical documentation?
Yeah, that's a great question.
Very good question.
The answer is no. You are not legally responsible to provide all accommodations that a student requests just because they request it. It is actually very common for a person to request, or maybe more than request, demand certain accommodations, and the the school saying, well, you asked for 4 things, we can do these 3 things. The bottom line is going to be, do they have access like other non-disabled individuals? But it doesn't have to be any specific accommodation. Obviously, you can't, or you shouldn't, agree to provide an accommodation that they can't use, or that's not going to help them. But you're not bound to just do what they say, basically.
Hmm. I also had a question here. Would a broadcast live ADA compliant solution be a good solution for classes and meetings, or closed captioning? So yeah, closed captioning and broadcast captioning are really going to be very similar. The only difference is that a broadcast captioner is typically more expensive than a non-broadcast captioner, because they're doing live events on television where there are hundreds of thousands or thousands of viewers. And so the stress level is different, and the unpredictability is a little bit different. So, and the qualifications are different. So in the case of one student live, just your standard card captioning will be more than sufficient. All of our captioners are doing, medical classes and chemistry classes and all different types of very advanced classes with vernacular and vocabulary that's very challenging, and they do an excellent job almost all the time. So yeah, I think that would be simple enough and good enough. If a student is from out of country and unable to provide documentation of a disability or substantial limitations, what do we do? I'm hesitant to provide accommodations, as this may create an unfair advantage to all other students who are required to provide updated documents. Wow. Mike.
I knew you were going to throw that one to me. Yeah.
Oh.
So my kind of gut reaction to that is, I understand the concern about the unfair advantage, but I'm not really sure it's an unfair advantage. Let me say it this way. You can't ignore the accommodation request, and you can't ignore someone with a disability because they can't provide certain documentation. I guess I would say I don't know what the disability is, but if the disability is obvious, then you can certainly proceed without getting documentation from a doctor or physician. So I think in that situation, you still have to have the conversation with the individual or the individual's family, and try to resolve providing some sort of auxiliary aid or service, even though you might not be getting the documentation you require. If you think about it, the alternative is a little strange, right? We knew that the individual had some sort of disability, or they're telling us, but we refused to provide an accommodation until they brought in a doctor's note. I know it's not that, I know I'm being a little glib with that, but that's not a very good alternative. And that's the sort of situation that I wouldn't be surprised ended up with attorneys.
Right. Thank you, Mike. Yeah. I've got an interesting question here. And it says, here we go. For virtual learning, a school is required to provide, I think it's a question, is a school required to provide ASL translation if they are using a virtual platform and if the child cannot read yet? Now that is an excellent question for the K through 12 space. We happen to be a vendor for the Department of Education in Hawaii. So we're on all of the islands in Hawaii doing remote ASL and some captioning for the K through 12 schools there. And it's brought us lots of interesting experiences right in this context of this question. Now, I can't speak to what the law requires, but I know what practice requires. And in the case of Hawaii, we see that almost all of the students have different requirements. And so it is a challenge. For the students who cannot read yet because they're too young, they oftentimes do speak ASL. So use ASL to communicate. And therefore ASL translation or interpreting is the only option. For the older students, really they decide whether they want it to be ASL or captioning. And of course, if it's on site and there's a deaf-blind situation, then it has to be on site. So because deaf-blind students require touch, which we've also done a little bit of. I'm scrolling down here to see if we didn't miss anything. There was a question about audits, Mike. Maybe that's a question to you. I know that you do audits regularly. Could you do an audit for ADA compliance?
Yes, we do that. We do accessibility audits and ADA compliance. We do. Someone also asked whether the recording would be available later. I don't know if they mean the recording of this presentation. I wasn't sure.
Yeah, I'm not sure either. I'm guessing that it is about this recording, and yes, we will make it accessible to the people who've participated here today. So there's another good question here. If a student was diagnosed in elementary or high school as an adult learner, do they need a doctor's note to get accommodations for ADD or ADHD, dyslexia?
Executive function, disorder. I actually do not know the answer to that. That's a good question. I don't know the answer under the ADA whether they would need documentation to get that. I think it's also a question of state law. You know, whatever state someone's in, very often the states have their own regulations and requirements about providing some of these accommodations. So I think that is a question for your local attorney to see what kind of laws would be in effect for that particular question.
Yeah, I'm not sure, and again, I'm not a lawyer or an attorney, but I have heard that there has to be a refreshment or an update every 4 years in terms of the doctor's notes. So that might be a kind of rule of thumb, but I'm not sure if that's going to be good legal advice for you.
Yeah.
It's not legal advice at all. It's just from my experience. Where does the law stand on English as a second language being a disability? I'm glad I got you here, Mike.
Yeah, it's not. It's not considered a disability. It's its own separate animal. You know, English as a second language. So that's not something that would fall under what we were talking about, Title III. It would not be considered an ADA disability. So you would have to address ESL issues, you know, again separately. Now it might have other legal implications, as we've seen ESL cases around the country. You know, it may implicate, you know, civil rights and those sorts of things, and denying services to someone because they don't speak English could also kind of spill over into maybe a national origin discrimination case or claim and those sorts of things. But it's not Title III.
I have a couple more questions we'll get to, and then unfortunately we're going to have to wrap it up. But I invite anybody who is here and has additional questions to reach out to us. Actually, Mike, if you could move down to the next slide, just so that everybody sees our contact details. Oops. Thank you so much. The last slide would be great. So if anybody needs to reach out to us, whoops.
I'll get there. Sorry.
You'll see our email and telephone numbers and all that in a moment. There you go. So please feel free to reach out to any of us. I have another interesting question here before we wrap things up. In California, we do not require updated doctor's notes. We accept IEPs at community colleges. So I hope that helps to answer somebody's question down there. So school systems deny. Give me a second here. Can we contact you for resources for ASL translation on learning platforms that use translations? For ASL, well, we do ASL translation, if that's your question. We also can help you with the learning platforms or with the platforms. What you mean by learning platforms, I'm not exactly sure. But, you know, give me a call or write me an email after this and I'll see if we can help you. And if we can't, we'll steer you in the right direction. So I think
I don't practice.
Does Michael practice in Maryland?
I was gonna say, I don't. Yeah, I don't practice. I'm not licensed in Maryland, but again, I can. If you shoot me an email and you need an attorney in Maryland, I can certainly give you a good referral. We have a pretty wide network.
I wanted to mention a couple of things before we maybe handle some additional or final questions before we lose people, because I see that we've had a few attendees had to leave because, you know, we have been on for a while. Before anybody goes, I really want to thank you all for joining us. We've enjoyed preparing this and we've enjoyed presenting for all of you. We hope you've enjoyed it as well and you found it educational and helpful. We really hope that you will spread the word and you'll join us for our these upcoming webinars that we have planned about ADA compliance. Another thing is that we'll be sending you a quick survey after we finish up. Please just take a few minutes and share your thoughts with us to help us improve our content for future audiences and maybe for you as well in future programs. You can also support the generation of more valuable content by liking and sharing our social media posts. There's going to be a little bit about this event. Please share that with anybody that you think might be interested. And also, we would love to hear from you, apart from all the things I just mentioned. So please send us a video clip, recorded on your phone with your thoughts about the webinar, maybe a brief written testimonial in the form of an email. We would love to share all of that with our audience and, if you permit it. So yeah, just stay in touch with us, be in touch with us and reach out if you have any needs or questions. And I'm looking here, I see lots of thank yous from everybody. So thank you. And I think we've gotten to all the questions. Yep.
All right, well, thank you.
And there's thank yous to our interpreters as well. Yes. And of course, I have to thank our interpreters. Thank you to all three of you.
Right.
Yep. Okay. And the captionists, that's what I meant. Yes, captionists, interpreters, all three of them. Thanks, Jerome. So, all right, well, we're going to be logging off then. Thank you to everybody. If you've got a question that I didn't answer or we didn't get to, please feel free to copy and paste it back down here at the bottom to kind of refresh so we can get to it. But we tried our best to hit everybody. Uh-oh, here we go. Could a school system deny a request for closed captioning in a Zoom meeting if it is available, however, the teacher refusing to enable the feature?
Talk to the teacher. Discipline the teacher. Teacher needs to do what the school system says. Teacher's an employee, sorry.
Yep. Yeah, you know what, funny enough, I'm sorry, I can't see your name, SH New, but it's a funny thing. As of COVID-19, we find that a lot of our setup activities are really educating professors and instructors and teachers about how to use their own equipment that they've been given by the school, how to turn on and off functions. It eats up a lot of time. but it's necessary to provide the service. So, so yeah, it might not be the teacher denying to do it or refusing. They might just not know how to turn on the feature or the function, and they're embarrassed to say so, which is kind of our experience. They prefer not to say anything than to admit that they can't turn on the feature for the 50th time, for example, in a row. So,
All right. Well, thank you, everyone.
yep.
Sure.
Thanks a lot.
Sure.
Yep. Thank you, Mike. And